200,000, the old agreement is void. That is unacceptable. We have a valid sale and purchase agreement.
We will not transfer the property at that price.
The key issues were whether the SPA was still valid, whether the defendant breached, whether the plaintiff was ready and willing, and whether the defendant could terminate or forfeit the deposit. Under Section 10 of the Contracts Act, a lawfully signed agreement is a valid contract. The principle that a person is bound what they say also applies. Specific performance is available under Section 11 of the Specific Relief Act, especially for land because damages are usually not enough. The plaintiff must also show readiness and willingness to perform. Section 17 and 21 allows the court to order or refuse specific performance based on fairness. The court also considers whether damages are sufficient. Under the Evidence Act, each party must prove their allegations. The principle that time is not of the essence in land contracts applies unless the contract clearly states otherwise or proper notice is given. The court held that the SPA was valid and remained enforceable. The delays did not terminate the agreement because time was not the essence. The defendant breached by failing to settle arrears and could not rely on her own delay to escape the contract. The plaintiff showed continuous readiness and willingness, and since the subject matter was immovable property, damages were not adequate. Therefore, the court granted specific performance and ordered the defendant to complete the same while rejecting her attempt to terminate or forfeit the deposit.
In my opinion, despite administrative delays, the plaintiff consistently demonstrated readiness to perform, while the defendant attempted to escape her obligation by relying on the obstacles she created herself. By granting specific performance, the court reaffirmed that the property transaction carried a higher expectation of fairness and that contractual duties cannot be avoided by shifting blames or altering terms unilaterally. The decision strengthens the principle that equity protects diligence, not opportunism.
I think this case is important because it shows that courts prioritize fairness in land transactions. The plaintiff acted in good faith while the defendant tried to escape her obligations, so specific performance was rightly granted. It reinforces that the land disputes are not always solved by damages and that parties must honor their contracts.
My view on the Mod Fuad case, the court's decision is sound and equitable as it correctly prevented the defendant from escaping her contractual obligations by relying on a delay that she herself caused. By granting a specific performance, the court reinforced the long-standing principle that land transaction demands stricter protection and that party cannot benefit from their own wrongdoing. The ruling also appropriately rejected the defendant's attempt to inflate the purchase price or forfeit the deposit, ensuring the fairness and contractual certainty.
In this case, the high threshold of continuous readiness and willingness demonstrated by plaintiff, which in court usually about having the money, but here the plaintiff went further by attempting to resolve the defendant's own liability. So this act was likely the tipping point for the court discretion. It illustrated that in equity, plaintiff will act proactively to save the contract, even facing the defendant mess. So this established a superior equity that made the remedy for specific performance almost irresistible to the court.
The High Court rightly granted specific performance because equity does not reward wrongdoing. Defendant's failure to pay dues meant that she could not rely on the lack of approval, breaching the clean hands principle. So by applying Section 11, Clause 2 of the Specific Relief Act, the court confirmed that damages cannot replace the loss of a home. The ruling ensured fairness by preventing her from escaping a valid bargain through her own neglect.
Justice for Vista buyers! We want our homes! Justice!
In the case of Rumaya Properties and Sisira Development, 4 issues arose. First, whether damages in lieu of specific performance should follow the original medium cost, Vista Damansara units, or the high-end Boulevard Residence unit. Secondly, whether the 2011 consent order required damages to be valid according to the Boulevard Residence. Thirdly, what is the correct effective date for assessing damages? In 2018 when the breach occurred or in 2019 when the Federal Court made its decision? Fourthly, whether the plaintiff could claim liquidated assessed damages and loss of rental. The governing law includes Section 21, Clause 2, Clause 3 of Specific Relief Act 1950, allowing the court to refuse specific performance if it causes hardship and to substitute damages. Section 26 and 28 set limits on enforceability and bar further claims once specific performance is dismissed. The doctrine of unjust enrichment prevents windfall profit, and the case of Johnson and Agnew requires damages to be assessed at the date the contract is lost. In this case, the plaintiff purchased 18 medium cost units for 2.6 million ringgit, but the Vista Damansara project was abandoned. The land was then sold to the first defendant who built the Boulevard Residence high-end condominiums. Then the plaintiff claimed 12.8 million ringgit based on the new development. The court refused specific performance because the original units no longer existed and the project had become entirely different, causing hardship to the defendants. Awarding the Boulevard Residence value would result in unjust enrichment, giving the plaintiff a 5-fold windfall. The 2011 consent order applied only if specific performance succeeded. Once specific performance was refused, the consent order lost its legal effect. The contract was effectively lost on 11 March 2008 when the land was transferred and performance became impossible. This decision illustrates the court's firm stance that equitable remedies cannot be manipulated to secure a more lucrative outcome than the contract originally contemplated. By rejecting the plaintiff's attempt to rely on the high-end Boulevard residence valuation, the court reaffirmed that damages must reflect the true contractual bargain and the condition at the time performance became impossible. The ruling strengthens the principle that specific performance is not a tool to reshape bargains, but a remedy grounded in fairness, practicality, and the prevention of unjust enrichment.
In my opinion, this case shows that specific performance cannot be ordered when the subject property no longer exists, so damages must be awarded instead under Section 21(2)(b) Special Relief Act. The federal court stressed that equity prevents a purchaser from receiving more than what was agreed, and damages should be calculated from the date performance became impossible.
Finally, on the decision of the Rumaya Properties case, the court's refusal to grant the specific performance was justified, as compelling the defendants to deliver non-existence unit or substitute them with a high-end condominium would have created a severe hardship and produced an inequitable windfall for the plaintiff. By limiting the relief to damages based on original medium cost units, the court rightly reinforced the principle that equity prevents parties from receiving more than what they bargained for. The decision maintains fairness and preserves the integrity of contractual remedies in a situation where the original project has become impossible to perform.
I believe that the federal court decision clarified the precise natures of damage in lieu of specific performance. The plaintiff attempt to claim the value was essentially a claim for the defendant investment rather their own contractual loss. Equity is compensatory, not punitive. It aims to put the injured party in a position they would have been in the original contract being performed. So this decision serves as a reminder that while equity is flexible, it cannot be used to rewrite the commercial risk and reward allocation of the original agreement.
So in my opinion, the Rumaya Properties ruling reflects equity's role in preventing unjust enrichment. I agree with the Court of Appeal's refusal to let the plaintiff turn a 2.6 million ringgit bargain into a 12.8 million windfall. By applying Section 21, subsection 2, paragraph B of the Specific Relief Act, the court rightly limited damages to the actual loss and avoided unforeseen hardship for the defendant. The dismissal of the consent order was also correct, since procedural orders cannot override substantive fairness once specific performance is denied. So this decision reinforces that remedies must preserve the original bargain and not reward opportunism.
The company rushed to court and obtained two major orders. Anton Pillar order, allowing searches.
In this case is first, whether the plaintiff has satisfied the requirements for the grant of an Anton Pillar order. Second, whether the plaintiffs met the criteria for a Mariwa injunction. Third, whether the plaintiff's alleged financial weakness or impecuniosity prevented them from offering a meaningful undertaking as to damages. Fourth, whether the plaintiffs failed to make full and frank disclosure of material facts when obtaining the ex parte injunctions. So lastly, if such disclosure existed, whether the court should nevertheless grant fresh inter partes injunction in the interest of justice. Getting into the law part, for an Anton Pillar order, the court applied the classic test from Anton Pillar KG versus manufacturing processes, which requires the applicant to demonstrate three things. First, an extremely strong prima facie case. Second, the likelihood of very serious damage if the order is not granted. Third, clear evidence that the defendant possesses incriminating documents or materials together with the real possibility that this will be destroyed if notice is given. The principles were reinforced by later cases such as Yusuf versus Salama, which further stressed the risk of destruction of evidence must be real and supported by concrete facts and not a mere speculation. For Mariwa injunction, the court relied on the well-established threshold from 9 Nia Maritime Corporation versus Triff, which holds that a plaintiff must show a good arguable case, meaning a claim that is more than barely capable of serious argument. Though it need not be proved on the balance of probabilities at this stage, the second requirement is the existence of a real risk that the defendant will dissipate assets to defeat any judgment. This element is determined through conduct demonstrating dishonesty, secrecy, movement of funds, or shielding of assets. Malaysian authorities, particularly SRC International versus Najib Raza, reinforced that the court inferred dissipation risk where there is evidence of dishonesty, concealment, breaches of court orders, suppression of financial information, or fraudulent division of funds. On the question of whether a plaintiff's impecuniosity defeats an injunction, the legal position is that financial weakness is not a bar to relief. This principle is supported by Allen vs. Jumbo Holdings, which recognizes that impecuniosity alone is not a sufficient basis to refuse an injunction. The rationale is that the undertaking as to damages, while important, must be viewed in context. And lastly, in the duty of full frank disclosure in ex parte proceedings is a fundamental requirement under Malaysian procedural law. As articulated in Cosmo Palm Oil versus Korporasi Serba Usaha Makmur, an applicant must disclose all relevant and material facts, whether favourable or unfavourable, because the court hears only one side at the ex parte stage. However, following the Damayanti versus Jigala case, the court retains discretion to grant a fresh injunction on inter parte basis if, notwithstanding the earlier non-disclosure, the justice of the case still demands the protection of an injunction.
So for the application, the court found that the plaintiffs had a very strong prima facie case based on the clear evidence of misappropriation, which was the creation of fake email and fraudulent hiring to siphon funds. The defendant's behavior, which was hiding devices, lying about the company property, and deleting data and disabling CCTV, showed a real risk of evidence destruction, satisfying the Anton Pillar threshold. For the Mareva injunction, the plaintiffs met the good arguable case standard through unexplained transactions, the use of STWD to move money without documentation, and implausible explanations that involved SKM and Indonesia. The defendant's dishonesty and concealment indicated a real risk of dissipation. On the issue of undertaking damages, the plaintiff's financial difficulties were caused by the defendant's siphoning, so impecuniosity couldn't bar relief. However, the court noted that the plaintiffs failed to make full and frank disclosure during the ex parte stages, as they omitted important facts such as refunds and their knowledge of the SKM purchase. So, in conclusion, the court held that the plaintiffs met all the substantive requirements for both the Anton Pillar and Mareva injunction. However, because they failed to make full and frank disclosure, the original ex parte orders had to be set aside. Even so, the plaintiffs still had an extremely strong case supported by extensive evidence of fraud and concealment. There remains a real risk that the defendants would dissipate assets and destroy evidence. For that very reason, the court exercised its discretion to grant further inter partes Anton Pillar and Mareva orders to protect the plaintiffs from further harm.
In this case, despite penalizing the plaintiff for non-disclosure, the court ultimately prioritized preventing further fraud and asset dissipation by granting fresh inter partes order. The ruling shows that while procedural honesty is essential, the court will not allow technical lapses to overshadow compelling evidence of deceit, ensuring that the interim remedies continues to serve their true purpose, which is to protect the integrity of justice in serious commercial wrongdoing.
This case demonstrates that Anton Pillar and Mareva injunction requires strong proof and must be carefully justified. Even where the disclosure was imperfect, the court could still grant injunction because the evidence of fraudulent conduct and risk was serious. It concludes that such remedies depend on real risk and proper procedure.
My comment on the IOU pay case. The court's decision strike a balanced and principled approach, acknowledging the plaintiff's significant non-disclosure while still ensuring that justice is not derailed in the face of clear demonstrated fraud. By setting aside the ex parte orders but granting fresh inter parte injunctions, the court reinforced the importance of procedural integrity without allowing the defendants to benefit from their own misconduct. This outcome appropriately safeguards both the fairness of the process and the substantive rights of the aggrieved party.
I found that the court treatment of the undertaking as to damage is important. The defendant attempted to use the plaintiff's financial weakness as a shield to block the injunction. However, the court rightly applied the principle from the Union Shirt Factory, holding that it is inequitable to deny relief based on lack of funds when that financial distress was caused by defendant alleged misappropriation. It ensured that injunction remain accessible to victims of fraud, even when the fraud has left them financially vulnerable.
IOU decision highlights equity's priority on the interest of justice over technical lapses. Although the plaintiffs failed to make full and frank disclosure, the court rightly set aside the ex parte orders but granted fresh inter parte injunctions. So this was necessary because the defendant was actively concealing evidence, and equity cannot allow fraud to prevail simply due to procedural mistakes. So the ruling ensures that remedies serve their own purpose, protecting fairness and preventing wrongdoers from escaping liability.
Court rules against the defendant, Mr. Cedric Wong, finding him liable for fraud and breach of agreement. His appeals have been dismissed.
The main issue here, first, were the requirement for the inter parte Mareva injunction actually met. Second was the appeal against the initial ex parte purely academic since it had already lapsed. And third were the terms of the injunction oppressive, specifically regarding the financial limit and the requirement to disclose all assets. Moving on to the law, there are three elements: good arguable case, proof of asset within jurisdiction, and real risk of dissipation. As per case of Zainal Abidin, there must be a cogent evidence that the defendant intend to hide asset to defeat the judgment. The court also looked at ancillary order. These are orders to compel defendant to reveal their asset. So how did the court apply this? First, good arguable case. It was easily met since the federal court had already affirmed the appellant liability for fraud. The second, the risk of dissipation. The court looked at the appellant past conduct. Since he had already proven himself to be dishonesty, so he would do the same, lose his asset to avoid paying damage. However, on the issue of oppressiveness, the court agreed with the appellant to order the disclosed asset only up to 30 million value, not everything he owned. So in conclusion, the Court of Appeal dismissed the appeal. They held that the challenge to the expired ex parte was academic and moot.
This case underscores the court's willingness to deploy Mareva injunction that past fraudulent conduct signals a genuine threat to the enforceability of future judgments. The appellant's deliberate diversion of joint venture was more than a historic wrong. It demonstrated a level of dishonesty that made asset dissipation a realistic concern. By affirming the injunction, the court highlighted that Mareva relief is not punitive but preventive, aiming at preserving the integrity of the litigation process so that a successful plaintiff is not left with a hollow judgment.
Although the Mareva injunction was justified, the case raises concerns about how easily courts into a real risk of dissipation based on past misconduct. Freezing large assets before damages are assessed may be harsh, showing the need to balance protecting judgment creditors with avoiding overly restrictive orders.
My opinion on Cedric Wong's case, the court's decision to uphold the Mareva injunction is well justified, as the appellant's prior fraudulent conduct created a genuine and credible risk of asset dissipation that could undermine enforcement of judgment. By affirming the injunction, the court reinforced the principle that equitable relief is necessary to prevent dishonest parties from defeating legitimate claims. However, the decision also highlights the need for courts to vigilantly balance protective measures with the risk of overfreezing assets, ensuring injunction remain proportionate.
In my opinion, the good arguable case here was guaranteed. Why? Because the federal court had already affirmed the appellant's liability for fraud, so this elevated the claim to a certainty. The Mariva injunction was therefore critical in the post-victory phase. It stopped the defendant from stripping the asset when they know they had definitely lost.
For this case, it shows that equity's refusal to let technical missteps overshadow proven fraud. Although the plaintiff's affidavits was invalid under the Sabah rules, the error was corrected with fresh filings. More importantly, the defendant's fraudulent conduct created a genuine risk of asset dissipation, justifying the Mariva injunction. The court rightly held that the procedural defects cannot become a loophole for dishonesty, and this ensures that equitable relief protects the integrity of justice rather than enabling wrongdoers.